traffic actually wasn't that bad at all. It's not some sort of awful condition. Okay. Questions on your mind? Questions on your mind? Anything about Hearts of Atlanta, about Katzenbach, about the New Deal? Anything on your mind? Yeah, James.
Clarification for the Katzenbach, that was that, like the aggregation, like that they would aggregate all activity in order to find them.
Well, with Katzenbach, let me put it this way: both Katzenbach and Hearts for Atlanta don't really need to even require the aggregation principle. And the reason why is that they deliberately attract the business from out of state, or they use supplies from out of state. So indeed, their business did affect interstate commerce. You don't even need to aggregate it. The case where you need to aggregate is Wickard and today, Gonzales versus Raich. That's where you need to do the aggregation, because both growing the wheat and growing the marijuana was activity solely within one state. So that's actually where it matters the most. Okay. Any other questions? Yes, Jamie.
Can I ask you a question pertaining to this case?
Which case?
The marijuana case.
We'll do that at the end of class. Can you hold on?
Yeah.
Please do. Yeah, well, I promise to spend half an hour on it. I promise.
Okay.
Thank you. Any other questions from last week? Yes.
You said
In which case, I didn't hear the word you said.
the marijuana case.
Right. We'll talk about that today.
Right, but you were talking about the part about aggregating, and also I think.
Wickard.
Okay, so but in the case right before, right, it was saying that you
Raich.
that you couldn't aggregate. In gun case, you couldn't
You're
aggregate.
exact. We will talk about this exact question today. I promise. You're right. It's a tension. You're pointing out a very good tension, which I will highlight in maybe about an hour. Anything else on Wickard by itself without reference to Raich? I realize when you do cases that are somewhat sequential, you don't get the doctrine all at once. So you have these very good follow-up questions, but let's try to walk through this in sequence. Anything else? Okay. So the topic for today focuses on the Commerce Clause as well as its close cousin, the Necessary and Proper Clause, in the context of what might be called the Federalism Revolution. And I don't particularly like this phrase because it makes it seem like the court suddenly reversed lots of old precedents. It did no such thing, but it definitely changed the trajectory. So if you had gone to law school in the 1970s or the 1980s, the professor standing up here will tell you, yeah, under the Commerce Clause, Congress can do whatever it wants. Your teacher may have said, yeah, under the Commerce Clause, Congress can regulate any activity. Don't worry about it. In fact, if you actually looked at the case books from the 70s and the 80s, they dedicated a few pages to the Commerce Clause and basically said, this is settled doctrine. Whatever Congress wants to do, no matter how local, Congress can do. This would not prove to be the case forever. Throughout the 1970s, 80s, and into the 90s, you had a majority of Republican presidents. And they began to appoint justices who were, on average, more conservative than those they replaced. So the court affected a shift to the right. And part of that shift was to restore a focus on what could broadly be known as federalism. Okay? Federalism. This manifested in a couple different ways. One of which is by putting limits on the Commerce Clause. Another attribute is by making it harder to sue the states. We'll talk about that second part later. But the courts began to make it much tougher for the federal government to control what the states do. One of the first big cases to signify that there was a shift in doctrine was Lopez. And I just want to make this point at the outset to be clear. Lopez didn't try to overrule Wickard. It didn't try to reverse any New Deal precedents. What it effectively said was, we have Wickard, we're not going to change it, but we're not going any further. My colleague Randy Barnett has written, this is like saying this far but no farther, right? We will say we did this in the 30s, that's it, we're going to draw the line here. And I think it's against this frame that you should understand Lopez. Okay, so let's actually talk about the facts of Lopez for a minute. Anyone from San Antonio? Anyone know Thomas Edison High School? Yeah. Okay, very good. So Alfonso Lopez was a student at, hold on, one at a time, guys, one at a time, at Edison High School in San Antonio. And he brought a gun to school. Okay, where did I leave off last time? Someone volunteer. Where? Is that Patrick? Are you going like this?
I don't know who's left.
Okay, Brandon, I'll call on you. Okay.
I was last, but I'm good.
Okay, well then if you last, Patrick, you're up. What happened, Patrick, after Mr. Lopez brought his gun to school?
That day or just,
Well, walk me through the aftermath.
they arrested him.
Who's they?
Police authorities arrested him. Found a 38 backpack.
Were these state police or federal police? Okay, so they were state police officers, right? These are not FBI agents that arrested him, right? Could he have been charged, Patrick, under state law for carrying a gun in a school zone?
Yes.
Okay, right. So even back then, under Texas law, in the absence of a permit of the appropriate sort, you can't bring a firearm to school. And actually, this is indeed Edison High School in San Antonio. I had a friend who sent me these pictures. This is the gymnasium. This one I got, I don't know how I found this, but out of the blue, someone who went to high school with Lopez sent me a copy of their yearbook and sent me these really blurry photos. So that's him. That's the best I got. That's, you know, I tried finding a picture of this guy. It's a fairly common name, but this I'm pretty sure was the Lopez from that year at Edison High School. And there's his name, Alfonso Lopez. And here's a picture of him playing soccer from the high school. Again, I'm really sorry. I know it's blurry. It's hard to make out, but this was the year he was there, so I'm 99% sure this is actually him. It says, rushing down the field, Alfonso Lopez warms up before the game. Okay, so this is warm up before the game. This is before he got arrested for bringing a gun to school, I suppose, right? But he wasn't simply brought up in charges in state court. Georgina, what happened to Mr. Lopez? Why were federal charges brought if it was perfectly valid to bring state charges? You know? Charles?
Assuming they wanted to give them the most severe charge or punishment.
Ah, I think AJ.
I think they said that he violated the gun-free school zone act.
Oh, he definitely violated the federal act. No doubt about it. But why would the feds bring the charge? Why wouldn't they just let the states take care of it?
It's the argument they were making was that school violence impacts commerce.
Okay. So, anyone else want to take a stab at it? Yeah, you're next. Go for it.
State budgets.
Oh, state budgets. What a good answer. Give me more. Give me more.
So it's easier for since the states have a smaller budget, it's easier for the states to be like,
yo, we're gonna take credit for this.
Exactly.
But
100% correct, right? Think about it. The local sheriff, right, busted this kid for bringing a gun to school. They take all the credit, but it doesn't tax their prosecutors. It doesn't go to a state prison. They don't have to deal with any of the diversion. Throw it all to the feds. So I think the word that Alex said is right, is they can take credit for it, but they don't bear any of the responsibility or the blame, right? This is like the responsibility of the dual sovereigns when you have multiple executives, right? You know, you can take credit when it's good, but, you know, shirk it off when it's something that's bad for you. So, yeah, exactly right, guys, right? They said, look, why are we going to waste our time prosecuting this kid who's dead to right? He did it, no doubt. Let's let the feds handle this. But AJ's point, I think, is also good. This was a fairly new law, and I suspect the feds wanted a case to test it, right? They wanted a case. They wanted to like, put a prosecution under their belt for a gun-free school zone violation because it was a fairly novel law. And there's no doubt that he violated the law. Look, he was within 1,000 feet of a school zone. He was there. He had a gun. There's no doubt that he violated the plain text of the law. One note, you'll do this in property. You often read about laws that say, you know, for example, a sex offender can't live within 1,000 feet of a school, a playground, a church, whatever, right? I want you to look at a map of any major U.S. city and try to find a single place that's not within 1,000 feet of a school, park, playground, church, something else. These places do not exist. There are no such places. These are mainly things to basically zone these people out of existence. And what you actually see happening is in places like Miami, where sex offenders live under highway overpasses because it's only anything far enough away from an actual school, park, playground, whatever. That too, right? Basically, they can't live anywhere. And the irony is they can go. They can hang out at a park all day as long as they don't live there, which is why these laws are largely ineffective. I'll give you one story when I was clerking. This one drove me nuts. So everyone know what a methadone clinic is? This is a clinic that people with opiate addictions go to get treatment, right? Methadone is like an alternative. It's supposed to get them clean, whatever. But you have to get this through a clinic. So there was an announcement, this clinic wants to open up in this town. The town's like, okay, we don't want these guys. So they passed a law barring any methadone clinics. Okay, that was illegal, violates disability law, whatever else, right? Fine. They passed a new law. They said, well, you can't build a methadone clinic within 1,000 feet of a park, school, playground, church, whatever else, right? Okay, they've actually found a place in the industrial zone, right? All the way out on the outskirts of town that was not near anything. So you know what happened? Ready for this? There was a little strip of grass on the sidewalk in front of the clinic. The city designates it a park. You think I'm joking? Eventually, this case, I clerked when I was there, but it went on and on and on. So eventually, the court said that they acted unlawfully. But this entire business about you can't be within 1,000 feet of X is merely a way to, you know, zone out of existence certain things you don't want. Okay, everyone with me so far? Okay. So, who am I up to? Okay, Josh. Perfect. Josh, so you're the lawyer for Mr. Lopez, right? You're a federal public defender. Your docket is high. You have more cases than you can possibly deal with, right? And if you ever want to do a lot of good work as a defender, it's a good job, but you're going to be so overworked you won't have enough time. But it's important work to have, and I hope some of you consider that career path. So, Josh, you're Mr. Lopez's lawyer, and your guy's dead to right. He did it. He brought the gun. There's no doubt about it. Okay? And what do you think in most cases the public defender would have recommended Mr. Lopez do? The guy was probably 17 or 18 years old, young guy, has a whole life ahead of him. Plea out. What do you mean plea out? Yeah. So I don't know the exact number, but like 99%, it's got to be something where 95% of cases never go to trial. The defendant takes a plea bargain. That means says, you know what? I will confess that I broke this law, and in exchange, you give me a reduced sentence. He was probably 18 years old, right? Maybe he can get a lesser jail time, whatever. But Josh, did the guy's lawyer roll the dice and simply say, "Yeah, I'm gonna take a plea deal"? Is that what happened? No, they litigated it, and this is why I often use this point to encourage students to never view constitutional law in a vacuum. And people say, "Oh, Josh, I want to do constitutional law in my life," right? That doesn't require you to work for the American Civil Liberties Union. This guy's lawyer was a public defender. I've looked him up. I emailed him, never emailed me back, but I tried. I want to compliment him. This guy's lawyer didn't take what his law professors took him for granted, right? He didn't accept the law in his book as fixed. Everyone probably told him that the Commerce Clause is a dead letter, that Congress can do whatever damn well pleases. He had other ideas. Instead of telling his client to take the easy path and just simply plea out, right? He said, no, dude, you're going to trial, and we're going to challenge this as beyond Congress's commerce powers. I'm sure that people at his office said, what are you, insane? Why are you risking this kid's life? He's 18 years old, going to be stuck in jail for 20 years for a simple gun possession. Plea out to a misdemeanor. Let this one go away. But for whatever reason, he had a conviction, and he persuaded Lopez to. I give credit to Lopez also that he was willing to risk this, because you could have had a significant jail time. So they challenged it. He did not listen to his common law professors, right? Another reason why don't listen to a word I say. I don't say this lightly, but in this class more than others, always think critically and think carefully about how precedents are structured and what avenues exist to challenge long-standing precedents, right? The beauty of this case is that Lopez never asked to overturn Wickard. He never asked to overturn Hearts of Atlanta. He never asked to overturn any case. He put together an argument that fit specifically, narrowly, right, within existing framework. If you walk into court and say, Mr. Chief Justice, you need to overrule the 70-year-old case, they're going to laugh you out of court. But we say, Mr. Chief Justice, there's this case and it didn't quite reach this. There's a difference, right? And let me explain what this difference is. You got your shot. Okay? So Isaac, what was, going back across the far gap of the room, what was, Isaac, what was the argument that Lopez's attorney put together that fit within these New Deal precedents without asking to overturn a thing?
His argument was that there was connection between interstate commerce and the possession of firearms and property, that they were too speculative and too attenuated to stick.
Okay, well, you're giving me good answers, but I want to be a little more precise. Let me ask you a follow-up question. What did Wickard say Congress could regulate?
Anything that substantially affected
Use this word anything. Give me a synonym for that.
economic activity.
I think I said this last week, right? The key phrase, right? The key phrase from Lopez is that Congress can regulate any economic activity that has a substantial effect on interstate commerce. Any economic activity that has a substantial effect on interstate commerce, right? This is what we did last week. So, Camry, I'll ask you the follow-up question. Is there any economic activity at issue in Mr. Lopez's case?
No, according to the defense, but the government of the United States is saying that bringing guns to school affects education.
Oh, wait a minute. The narrow question, right? Is actually possessing a gun by itself economic activity? No. Therefore, does it matter if it has a substantial effect in interstate commerce in the majority? No. That's exactly right. The key move, right? And this is the point that most people simply don't appreciate about Lopez. Like, wow, Lopez was changing all the New Deal cases. No. They actually took the New Deal cases at their face value. The New Deal cases said any economic activity that has a substantial effect in interstate commerce is something that Congress can regulate. But if it's not a economic activity, then Wicker doesn't apply. So the holding, right? The holding of Lopez, and we'll go through the case in a minute, can be summarized as this. If there's an activity that's wholly intrastate, if there's an intrastate activity that's not economic, Congress has no power. If there's an activity that's intrastate and it's not economic, then Congress lacks the power to control it. Even if it does have some sort of spillover effect in other states, right? The activity itself is not economic, and therefore Congress has no power to regulate it. Everyone see that? Okay, John, let me ask you a follow-up question. How could Congress have written this law differently to ensure that it was upheld? How could Congress have drafted this law differently? Well, let me ask you this question, John. How does somebody get a gun? How did someone acquire a gun? Or, yeah, I mean, with criminals it happens both ways, right? But they acquire it. And John, where did that gun come from? Was it manufactured in Texas? Do we know? Is it safe to say that maybe some of the gun wasn't manufactured in Texas?
Yes.
So that's the question again. How could Congress have drafted a statute to perhaps get it upheld?
And I guess like some of the good parts.
Ah, well, okay, getting closer. Alexa, how could, he's on the right track, how could Congress have written this statute differently to not run into this problem?
If they would have included talking about buying or selling.
Ah, okay, so you're a member of Congress, you're drafting a statute, right? Give me, what would that statute look like? You're exactly on the right track.
That it's illegal to bring a gun in a school zone or buy a gun.
Well, the issue is not selling it, right? The issue is possession, right? How could you modify this possession statute to bring it within the Commerce Clause? You're exactly on the right track. You didn't give me the answer.
Buying or selling any gun that goes through interstate commerce.
Oh, exactly right. Exactly right. So what if Congress wrote this statute, right? Any person who brings a gun into a school zone is guilty of a crime if that gun traveled in interstate commerce. Ah. They can define the economic activity more broadly. So the problem is the economic activity is not possessing the gun. The economic activity becomes possessing a gun that traveled in interstate commerce. Alexandra.
But then wouldn't the court come back and say that they were just finding a roundabout way to do something that the states should do like they did in that case that we went over last week with the child labor laws?
Oh, what a good question. Okay. So what I'm saying is actually not a hypothetical. The fascinating part of this case, and was this in our version of the book? I can't remember if they edited this out. But while this case was being litigated, Congress enacted an identical statute, but with one added phrase, interstate commerce. They basically rewrote the same law, but they specified that if the gun traveled interstate commerce, which I think virtually every gun does, bullets, things are made out of state, right? Then Congress can regulate it. So Congress tried to actually moot the case by passing this new law. It didn't work. Why? Because Mr. Lopez was convicted under the old statute. And if the statute's changed after the fact, you can't modify it ex post facto, right? So that failed. So indeed, today, we actually have a federal gun-free school zone law on the books that is used all the time and has been upheld because the law has what we call a jurisdictional hook. What is a jurisdictional hook? Congress recites some magic words, right, that bring it within their powers. All the statute says is possession of a gun that traveled interstate commerce is an economic activity, and because that economic activity has a substantial effect on interstate commerce, Congress can criminalize the possession. Possession by itself is not enough to be a federal crime. It's possession plus some sort of interstate commerce, some sort of interstate activity. By the way, preview for Raich. What if the gun has no interstate activity? What if the marijuana has no interstate connection? That's why Raich is the real case to study. We'll get there in about an hour or so. But the holding, right? And I'll walk through Lopez because Justice Rehnquist does a good job at explaining Commerce Clause jurisprudence. But the holding of Lopez is Congress, don't be lazy. This is Alexandria's question, right? Congress, don't be lazy. If you want to regulate local intrastate activity, put in some magic words, this jurisdictional hook, and find a way to connect it to something, some economic activity. And that will uphold the statute. So even though the court struck down the Gun-Free School Zone Act that Lopez was convicted under, the subsequent law, enacted I think a year or two later, was upheld because it has this jurisdictional hook. So I'm going to get the general gist of Lopez and the importance of the fact that there was no economic activity at issue in the case. Everyone get that? Okay. All right. Now let's actually dig into the case a bit. One of the reasons why Chief Justice Rehnquist was very good is he was a very clear writer. And this case provides a very good overview of the Commerce Clause cases, a very good synthesis. And in fact, when you guys are making your outlines for finals, I would use Rehnquist's summary as a very good overview of like 80 years of common law. He does it far better than I ever could. And when he does it, that makes it law also. So it has a significant presence. Okay? But Rehnquist's opinion begins with this great line, which I love. He says, we start with first principles. Right? Gladys, what does that mean, we start with first principles? What's he signaling there? What's he doing there?
I guess he could refer back to like the statement in the Constitution, like the rights.
Yeah. He's basically saying, let's be originalists for a moment. Right? Justice Scalia very famously made a concept known as originalism. He didn't invent it, but he made it famous. And it's the idea that we should interpret the Constitution as the framers would have understood it. So he's saying, look, we're not getting rid of these New Deal cases. Wickard's here, whatever. We're not getting rid of it. But if Wickard doesn't control, we will not read it any more broadly. And to move beyond Wickard, we will look to first principles. And he cites a very famous passage from Madison in Federalist 45. And in Federalist 45, Madison wrote, the powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. And that the division of authorities between the state and federal government are adopted to, quote, ensure the protection of our fundamental liberties. A healthy balance of power between the states and the federal government reduces the risk of tyranny and abuse from either front. This is but a parallel of the idea that ambition must counteract ambition that Madison wrote about in Federalist 51. I was actually on the BBC the other day doing a radio hit, and they asked me, "So tell us about the American tell us about the American checks and balances." So I said, "Well, we have them because of our tussle with you from 1776." And the host started laughing. Why are you not laughing? It was a British radio show. I was lecturing them, and I said, we designed our system to avoid the tyranny of your crown. You can listen, it's on YouTube, you can listen to it. Anyway, so I enjoy that very much. But the idea was we developed the system we have to prevent the risks of tyranny. I was actually invited back, so it wasn't that awful. But Rehnquist is making the point that federalism exists to preserve this check on federal power. And then he walks through the doctrine, beginning with Gibbons, right? And even as early as Gibbons versus Ogden, Marshall said, commerce, even within one state, can be regulated by commerce so long as it's among the states. You have this intercourse, right? You can't regulate completely internal commerce, but it can go inside of a state. After Gibbons, there weren't many cases for nearly 70 or 80 years because Congress didn't really do much about regulating state governments. That changed in the late 1800s when you have things like the Interstate Commerce Act and the Sherman Act. And Rehnquist walks through E.C. Knight. E.C. Knight, you may recall, is a sugar case. They said that, well, commerce is not the same as manufacturing, so Congress can't regulate manufacturing. Okay, you had the Schechter poultry case, which said this was a purely interstate business, and there was only indirect effect in other states. Of course, Schechter poultry was overruled, and the case that overruled it was Jones and Laughlin, NLRB versus Jones and Laughlin. That case eliminated the direct versus indirect distinction, and also held that if intrastate activities have a substantial effect in interstate commerce, Congress can regulate it. But even there, it'll still intrastate economic activities. That brings us forward to Wickard, right? Wickard was the furthest possible stretch of the Commerce Clause. This was the greatest expansion of Commerce Clause powers. And Wickard said, even if the economic activity is wholly intrastate, right? There's no indications will ever cross the state line. If there's a substantial effect in interstate commerce, then Congress can regulate it. But these cases, Rehnquist say, still show there's an outer limit on the Commerce Clause. You cannot eliminate the difference between what's local and what is national. Okay? So he puts together 3 categories of economic activities that Congress can regulate. 3 categories of economic activities that Congress can regulate. And I remember this through the acronym CIA. CIA. That is channels, instrumentalities, and activities. So first, the court held that Congress can regulate channels of interstate commerce. This was a case like Hearts of Atlanta, where you have highways and the such, and Congress has power over any activity that flows from the highways. You have instrumentalities. These are actually fairly similar to highways, with things like roads and the like, and railroads. So some sort of instrumentality, something that transports commerce from point A to point B, that is something that Congress can regulate. And what's the A? The A is economic activities. If an economic activity has a substantial effect on interstate commerce, like in Jones and Laughlin Steel, Congress can regulate it. Right? So Rehnquist, I think, synthesizes quite well, and this is even the law today, the 3 main categories of what Congress can regulate under its commerce powers. So first, I guess we're up to Colin. Colin, is the Gun-Free School Zone Act a channel or instrumentality of interstate commerce?
Yes.
Doesn't touch it. So what's the only possible category that it fits under, Colin?
Economic.
Yeah, economic activity. And this, as we said before, is why the law is valid, because the court finds that merely possessing a gun with nothing more is not economic activity. Funny story, not funny, but a number of groups have tried to make local guns. That is, guns that are manufactured entirely in one state. I'm talking the wood for the handles from one state, the metal is mined in that state. The stone, whatever they're using, everything's from one state. And they're saying, look, these guns are not subject to federal control. The courts have rejected those cases for reasons that will become clear in Raich. Because indeed, they've held possessing a gun may not be economic activity, but manufacturing it most certainly is. And even though you're not buying or selling it under the reasoning in Raich, that can be regulated. But we're not quite there yet. Your hand up?
Well, I'll wait for the.
Wait for Raich. A lot of this gets cleared up when you Raich, I promise. Okay. So for the activities sustained under the third category, this regulation of economic activity must substantially affect interstate commerce. Okay. Now, Schiffer. I'm sorry, Sheffa. Is there any indication that possessing a gun in a school zone does affect interstate commerce? Forgetting about the economic activity part, does possessing a gun in a school zone have a affect interstate commerce? What does Justice Breyer say? Justice Breyer is very animated in this case. This is like peak Breyer right here. This is about as good as he gets. We'll come back to the majority, so keep flipping back and forth. How so? What does Breyer say? So here's the argument. Let's walk through this, right? So Breyer says, she's exactly right. Breyer says, look, if people think that there are guns in school zones, they may be afraid to travel. And if people are afraid to travel, they may not cross the state line. And people are won't cross the state line, they can't get their kids to school, right? Imagine you live right in a border, you have to cross the border to go to school. Yeah, why are you laughing? No, why are you laughing?
It seems like compounding scenarios to arrive at a result of finding some minute possibility of economic activity.
Justice Breyer? Never. You also have your hand up also.
Yeah, like it's pretty real. Like he's having this domino effect. If this
Domino effect.
It'll
Domino
create
effect.
the economic collapse of the United States.
Okay. So what you're seeing, my friend, Cameron, you have something else? Exactly, right? What you have here is what the majority calls piling inference upon inference. Piling inference upon inference. Or Sergio framed it a domino effect. I like that also, right? This is not how we say logical, right? It's not a very close fit. Right? If a gun is in a school zone, yeah, maybe people may get afraid and they'll go back to school the next day, right? Or the next week. The idea that this actually has an effect on interstate commerce, it's possible, but not likely. One second. But Breyer's point is this, right? Breyer's no fool. He's not. He's like, our job as judges is to try to find ways to uphold statutes, unless they involve abortion. But our job as judges, it's true, we'll get to Holman's Health. Our job as judges is to find ways of upholding statutes. And if I can conceive of some way to uphold this statute, if I can make up these inferences or these dominoes and make up a scenario where having a gun in a school zone does have a substantial effect in interstate commerce, even if Congress didn't say a word about it, as a judge, that is my obligation, to find ways to uphold statutes. This, I'll get to you guys in a second. I see lots of hands. I'll get you a promise most time. This is what's known as a rational basis test. A rational basis test. This is a phrase you've seen and we'll see a lot more. The idea is, if Congress could have had some rational basis on which to conclude that a gun in a school zone affects interstate commerce, I will uphold the law. Even if Congress didn't, even if Congress was silent on this issue, if Congress could have these inferences, that's enough. So for Breyer, his job as a judge is to bend over backwards, right? Do gymnastics and find some conceivable basis on which this actually has an effect, even if Congress failed to. The majority said the opposite. They said, look, we're not going to make stuff up. If Congress wants to make a finding, that guns in school zones have a substantial effect to interstate commerce, they can do that. They did. And they made those findings, and the court upheld that law. But what the court's not going to do is make up these inferences for Congress. What the majority says is, hey, Congress, you want to make this economic activity regulated? Prove it. Give us something more than a generic statement. Okay, everyone get that? I saw lots of hands. Okay, I'll start with you, Krista.
Well, this is just kind of more in reference to Justice Breyer. Is that kind of how he rules, or formulates the judgment on?
Justice Breyer is what we call a deferential person. He loves deferring to Congress unless it involves abortion. And I keep saying that lightly, but if you read his decision, Holman's Health, he doesn't defer to the Texas legislature at all. In fact, he basically says they're lying. But in this case, he has an overwhelming sense of duty to defer to democratic norms, because his entire mission is to find ways to make democracy more effective. And he envisions a very small judicial role, except in a couple things that he gets excited about. But yeah, this is peak Breyer, right? This sort of hypothetical scenario of how this could affect interstate commerce. This is exactly the way he rules. Yeah, Heather.
My observation is that what Justice Breyer didn't really deviate from, I feel like, kind of like what they did with Hearts of Atlantic and Kaizenbad and all of that was kind of that,
Okay.
they can't travel.
So Heather's right. In the Hearts of Atlanta case, in the Ollie's barbecue case, the court certainly bent over backwards to find ways to uphold it. And as I said before, this is the court saying, yeah, we're not going any further than that, right? We'll apply this really deferential rational basis test for economic activity, but for non-economic activity, we're not going to give you that sort of uber deferential approach.
So where would, as far as like checks and balances go, where would Breyer draw the line? Like besides like abortion, as you said, like where does a rational basis fall short for him?
I don't think he's ever made a statute he didn't want to uphold as a basis. You'll read a number of Breyer opinions, but he's very much afraid of courts stepping into any sort of policy disputes unless it involves abortion. But generally speaking, he's very. Trust me, when you read his decision, Holman's Health, you know exactly what I'm talking about. He's usually very deferential, and if he thinks there's a way to uphold the statute, he will find a way to get there. Dan, you've been patiently waiting.
Would you venture as far as submitting perhaps an instrumentalist view to devise local policy with regard to gun control? It almost seems like you're towing into that water, but not really.
I'm sure this is on his mind. I'm sure it's on his mind. I don't. Instrumentalist is a loaded term, so I don't know about that. But he's definitely. Another thing about Justice Breyer is he loves social science. His wife, I think, is a psychologist, and he loves social science. So you'll read a case later this year called Brown versus Entertainment Merchants Association, which involves whether California can put restrictions on the sale of violent video games. And his opinion, which thank God is edited in your book, has page after page of social science data of how video games impact kids. A lot of that data wasn't even in the record. He got it from who knows where. He does this all the time. He has appendixes on his own initiative. It drives me nuts. But he does this, and he firmly believes that social science should be used to make better informed judging. Yeah.
Like in the long version, like you get the full brief. He goes on and on about how gun violence is going to have an effect on the productivity of the American worker.
Yeah. I mean, he. If you want to find some social science data to see how anything can affect interstate commerce, you can find that data somewhere. And Breyer does exactly that. But the important point to stress about Breyer, I don't need to beat up on him, is think about it this way, right? Where was I up to? Stephanie. So I said before that Congress went back and reenacted the exact same statute with like 5 additional words, commerce, right? What's the point, from Breyer's perspective, of striking down this law if Congress can enact the exact same damn statute 5 minutes later with a little bit of a tweak? What's the point then of striking down this law if Congress can fix it by basically doing the exact same thing with a few extra pages in the record? But if Congress would do the exact same thing by adding words, what difference does it make? Right? If they can sidestep this entire business by adding 5 words to the bill, what difference does it make? Yeah. Right. So Breyer's saying, I think this is basically a matter of principle, right? If Congress can still do the same thing they want, they can still regulate guns in school zones, then what the hell are we doing? Why are we wasting our time when they can do this, anyway? And I think Stephanie's point in response is a fair one. It makes Congress recognize that there are, in fact, limits on its powers. I think that's actually an important check, because whoever drafted this bill in 1994, whatever year it was, got lazy. And he probably thought, oh, man, the Supreme Court hasn't struck down anything in 40 years. Why would I even waste my time holding a hearing to discuss why this has an effect on interstate commerce? Let's just pass the bill and move on. But after this, they actually have to have a hearing and put witnesses showing what the effect on interstate commerce was. So there's actually a burden on Congress to make their statutes more precise. Maybe that's worthwhile by itself. Nathan?
This is more to do with like Congress at the time. Why do they find it necessary if states already enforce these kinds of laws?
Such a good question, right? So we said at the outset, I'll go to Renu. We said at the outset that Texas had a gun-free school zone law, right? Why does the federal government need to prohibit something that the states are fully competent to protect? Right? Why does the federal government need to criminalize an act that the states are fully competent and have already criminalized? What do you think? Okay, crack down, or what do you think? So Zishan, let me ask you a follow-up question, right? Let's say Texas decides to repeal its law and says, we want teachers to be armed, right? We want teachers to be armed. What happens if federal law still criminalizes it? What happens to the teacher in a Texas classroom decides to bring a gun? I think you already gave me the answer, but what happens if Texas legalizes possession of a gun in a classroom, but Congress still criminalizes it? So what good is that Texas law? Does it carry much weight? So the answer, I think both of you said this, it sets a national policy. The reason why you pass a federal law is to tell people in all 50 states, here's what you're going to do. We don't want Texas being rogue and laying guns to school zones because that may be something we don't like. So when Congress acts, and again, this was Bill Clinton's gun control agenda, which probably lost in the Congress in '94, these actions were meant to make a national policy that even if even if the state government allowed guns, this is now a federal crime and it's preempting state law. Yeah.
Like, couldn't Texas or states before this case have combated the statute by saying it's within our police powers to control the health, welfare?
Yeah, but let me give you another example, right? What if Texas says no guns in school zone unless you have a valid permit from the state, and the feds come and say no guns in school zone unless you're law enforcement? So the state would have allowed maybe a parent dropping his kid off to be armed to get a permit, but the federal law doesn't have that exception. You see how it intrudes upon the states? It tells them, you no longer get to decide how to manage your own school safety. We're going to set a one-size-fits-all policy nationwide. Everything's the same. So by making this a federal policy, you get rid of any sort of state-local decision-making. And this is how Rehnquist began his opinion by saying, the more powers Congress has, the less the states have. When you make a single federal policy nationwide, you eliminate the space for the local jurisdictions to experiment and reach different results. Everyone get that? Everyone with me? Yeah, Jay.
This still kind of comes back to they're using the Commerce Clause to basically circumvent that they're taking away the state's police powers. Like, essentially, because it doesn't come down to the states to have the ability to regulate that kind of thing.
Mm-hmm.
So by using the Commerce Clause, they're able to completely use that as a loophole and basically take away that police power.
Yeah, in fact, they're stripping the state's police power. Exactly right. Okay. Yeah.
Can I also fall under the supremacy clause if a federal act overrules state act?
Absolutely, yeah. If the federal government enacted a law that said no guns in the school zone, period, a state law to the contrary is void. Absolutely. Right? Everyone with me? Okay. I want to highlight one part of the Lopez opinion that'll be important later for Raich. The court does discuss a necessary and proper clause, and people often have difficulty with the connection between commerce and necessary proper. Wickard was not only a commerce clause case, right? Wickard was a commerce clause plus a necessary and proper clause case. How? The act of growing the local wheat was an intrastate activity. There was no doubt about that. But Congress had enacted a nationwide price scheme. They wanted the price of wheat nationwide to be a certain level. Okay? In order to standardize the price of wheat nationwide, they had to regulate local wheat. Or to say it differently, in order to have this nationwide price scheme, it was both necessary and proper to regulate local wheat. You see the connection? Wickard wasn't really a commerce case, it was a necessary and proper clause case. That in order to have an effective price control system, it was both necessary and proper to control Mr. Filburn's local source of wheat. Okay, so that will come into play when we do Raich in a few minutes. Okay. By the way, so Justice Thomas has a concurring opinion. If Justice Breyer is committed to upholding statute, Justice Thomas is quite the opposite. He's made it known in a number of opinions that he would reverse the New Deal in a heartbeat. And he thinks all these cases are wrong. The notion of stare decisis, this is that we stand by precedent. Justice Thomas doesn't believe it exists for constitutional decisions. If it was wrong, was decided, it's wrong now. And there's no sense of standing by wrong constitutional decisions because the people can't reverse them by statutes. So he would overturn Wickard and all these cases. Okay. All right, I did the Breyer dissent. Okay. Questions on U.S. v. Lopez? Questions on U.S. v. Lopez? Yeah, Alex.
So what happens if you own a house very close to a school, but you have like a gun? So like you could have a gun that's in a school zone, but you're like in your home as well.
I think there are exceptions if you live nearby, but it can be tricky if your driveway's there, right? That's why having a single federal policy is not a good idea. I mean, in many states, no one owns a gun, so that's not really a problem. In Texas, it is, because lots of people own guns. So you can imagine a single policy from Washington doesn't account for the fact that in Houston, a lot of people live across the street from a school, may have a gun in their house, and may be unwittingly breaking some law.
So like when you're talking about the guns and like being manufactured, everything's being manufactured in the state, like what would happen with, because in order to use a gun, you need to have the bullets too. So if the bullets were
They make the bullets locally too.
Okay.
These guys, I mean, I think it's called the Freedom Gun or the Liberty Gun or something like that. They legitimately try every spring, every screw, every pin is manufactured in the state. But the courts have held, to describe it briefly, there's a very big problem interstate gun market. And even though your gun might be interstate, for Congress to regulate this interstate market, they have to reach your local gun. Because what if you start making your local guns and they start shipping across the state line? Congress's scheme is defeated. So in that sense, necessary and proper gets you there, not commerce. All right, everyone with me? All right, so the next case, right, or before we get to the next case, I'll get to Morrison in a minute. But between 1995 and 2000, law professors had some of an existential crisis because what they thought was the law for 40 years that Congress knew whatever damn well pleased may not be the law anymore. And people were worried, is Lopez like a one-time deal, right? Is this a one-time deal? Or is this a new normal, right? Is this representing some sort of new direction in constitutional law? So the next case where the court actually tested this principle came about 4 or 5 years later, 2000, in United States versus Morrison. And this bill involves the Violence Against Women Act. One fun bit, Joe Biden sponsored both the Gun-Free School Zone Act and the Violence Against Women Act. So I think he has a distinction of having the most laws struck down that he sponsored. That's unconstitutional, but well, that's neither here nor there. The Violence Against Women Act, contrary to what the name suggests, has actually very little to do with violence against women. It's all gender-based violence. This is why the name makes it very hard to have any criticism of it. It's like, what, are you in favor of violence against women? It involves basically everyone who suffers from gender-based violence. And it's primarily employed in the immigration context, that if certain aliens claim that their significant other, husband, wife, or whatever, engage in some sort of physical or mental violence, they can get a adjustment of status for their citizenship. And this is used in many contexts to help people gain citizenship or otherwise. But the test case, the one that went to the Supreme Court, indeed involved a gender-motivated crime, right? So who am I up to? Yeah, Chris, here we go. Walk me through the facts, please, of Lopez. I'm sorry, Morrison. Okay, so this is Christy Brzon-Kalla, who was the person attacked, and she was basically assaulted by two members of the Virginia Tech football team. And I see some Baylor Bears in the room. The idea of football players behaving badly is not new. And this is a situation, Virginia Tech, like Baylor, is a big football school. These people are waving. Yeah, bear down, right? And it's a fairly big football school. And it's safe to say that in this town, the football players occupy a certain place of status, and that the members of the organization have an interest in these guys staying on the field and out of jail. So she was assaulted. And Chris, generally, if a person claims to be assaulted or raped or some other crime, who do they usually call? Well, you shouldn't call school police. They're not really police, but you call the local police, you call the state police, right? Schools should not be in the business of disciplining people. They don't have the infrastructure. Call the real police, right? You call 911 and you make an accusation of violence, rape, assault, whatever it is, right? Did the state police do anything for Ms. Brzon-Kalla?
There was charges against one of them. The other one was
Yeah. Basically, they got a slap on the wrist, right? These guys got a slap on the wrist. Maybe they were suspended from a couple games, whatever, right? But neither of them did any jail time. So what happened next, Cameron? After the state police, didn't really do much for her crime.
And now she is filing the case in the
Yeah. So Ms. Brzon-Kalla filed a case in federal court against whom?
against the two individuals
And
and the school.
and the school. That's the important point, right? Cameron, do you think this two guys she sued how much money?
No.
No, she wants to depop because of the law school of the university, right? Okay, so she filed suit. So Morrison was one of the players, and the other guy was Crawford. And she sues them. Whatever, these guys are, I don't think they ever made the NFL. I don't think they have lots of money. She can sue them. They have nothing. So what she actually wanted to go after was the university, Virginia Polytech. The problem there, and this is a topic we'll discuss later, is that generally you can't sue the state. And Virginia Tech is an instrument of the state. So in another part of the opinion, which I don't think is in your reading, maybe we'll have it later, the Supreme Court held that it was not permissible to sue the state institution. It violates state sovereignty to sue under this federal act. In other words, this federal act, VAWA, Violence Against Women Act, VAWA, cannot be used to allow them to sue. Okay, everyone with me? That's the first part of the opinion. But the second part of the opinion is, can she sue these individuals? Right? Can she sue Morrison and Crawford? Again, these guys have no money. There's nothing to be had. But this was a test case to determine the constitutionality of the Violence Against Women Act. All right. So, Kimberly, what does the court do with whether you can file a whether Congress can permit a lawsuit, excuse me, for gender-motivated crimes?
Well, the difference is that it's similar to the Lopez case, how Congress is trying to take away the state police powers
Uh-huh.
by, I guess, regulating violence.
Uh-huh. Okay, good. Let me ask you a follow-up question. You're exactly on the right track. Does the state police have the power to throw these two football players in jail? In theory, at least.
Well, we could.
Okay. Has it traditionally been the power of the federal government to regulate domestic crimes? And I mean domestic in the sense of not just domestic violence, but purely local crimes. Okay, good. So, Bernardo, how does Lopez then provide the rule of decision for this case? In what sense?
Lopez?
Yeah.
Essentially that, I guess crimes of violence are not economic activity.
Yeah, stop right there. Exactly right. A violence-based crime, right? A gender-motivated crime, the court holds, is not economic activity. Much like possessing a gun is not economic activity. So Lopez by itself provides the rule that Congress cannot regulate non-economic activity. But there's a big difference between the Gun-Free School Zone Act and VAWA, because Congress took the responsibility much more seriously here, right? Grant, what did Congress do for VAWA that didn't happen with the Gun-Free Act?
Well, they said they had detailed findings.
Yeah, Justice Breyer was really adamant here, wasn't he, right?
Yeah.
So walk me through that, Grant.
There was the detailed findings of found that gender-motivated violence dispersed potential victims from traveling interstate, being employed in interstate businesses.
Grant, why do you think Congress wasted their time with all these hearings and put this to the record for this law? What do you think? What do you think made them do all this extra work? Yeah, why did they make these findings? What do you think? What had just happened a couple years earlier? Rena, yeah. No, I'll come back to you. Why do you think?
I guess they didn't want what happened.
Yes, Lopez. I thought you were going to answer the question before. I'll come back to you. They learned their lesson from Lopez. They got burned in Lopez by not making the findings. Like, okay, Rehnquist, we'll take you up on your word, right? You want us to illustrate why a gender-motivated crime is economic activity with substantial effect to interstate commerce? We're going to tell you why. And they had all these hearings about, how women who are engaged in domestic violence are afraid to travel and they're afraid to get work. And they had very sophisticated findings, right? So, Jenna Marie, why didn't the government win here? So they pushed the ball a little bit from Lopez, didn't they? Right? They kind of moved the goalpost a little bit. Because Lopez said, look, this is not economic activity, Congress. If you want to go back to the drawing board and write something up and explain how this affects interstate commerce, we'll listen to you, but this is not good, right? But here the court says, basically, no matter what findings Congress includes, gender-based violence cannot be an economic activity. No matter what Congress tells us, as our own judgment, this is not economic activity. In other words, they're second-guessing Congress's judgment about what they did. In other words, So this is, I think, Stephanie Reno asked this question a few minutes ago. What's wrong with Congress just adding 4 or 5 magic words? The court's calling BS here. Like, yeah, you added all these extra words. Bogus. This does not actually change the fact they're trying to regulate a purely local activity that does not have any effect on interstate commerce. Reno, your question? Yes. I thought it was, which is why I came back to you. Other questions? Right? Alexandria?
Well, I mean, are the laws not the same in all the states in terms of like?
Are they?
Their-
Or let me ask this question differently. The law in the books, like the law for rape, right, is probably model penal code, right? It's probably the same in every state with some tweaks. But what varies from state to state or city to city?
The way that the jurisdiction.
Who made the decision to put these guys on, slap on the wrist? Not just the state police.
Well, the school didn't do it, but they can, right?
Yeah, James?
Jury?
Not the jury. Who knows what I'm thinking of? Yeah. The local prosecutor. In Blacksburg, Virginia, which is where Virginia Tech is. The local prosecutor, I'm sure, has season tickets to the football team. I'm making it up, but the point that Brazoncalo tried to stress is, even though every state has a rape law on the books, not every state will enforce it vigorously. And even more precisely, not every local jurisdiction, every city in a football town will enforce it as viciously. That's why a single federal policy lets a federal U.S. attorney appointed by the president, Bill Clinton at the time, to prosecute this even if the states won't. Right? This is basically saying if the states won't do their job to prosecute thoroughly, we can come in and seek damages after the fact. There's this passage at the end of Rehnquist's opinion, I can't remember if it's in your edited copy of the book, where he says, shame on any jurisdiction that doesn't punish rape. But what happened here, by all accounts, is the state didn't vigorously prosecute this allegation. Everyone with me so far? I saw some hands somewhere. With hands. Questions? Okay, go.
Sorry.
Yeah.
But wouldn't you say that vigorously pursuing recovery would be necessary and proper?
Well, so here's the rub, though. If it's not economic activity, then it doesn't matter. The only sorts of intrastate activity Congress can reach are that it's economic in nature. So if it's not economic, you don't even trigger the necessary and proper clause, which is why
doesn't work separately from the Commerce Clause.
necessary and proper is only triggered when there's actually an economic activity at stake. Which is why in Raich, the court held that marijuana cultivation was an economic activity, which is why you get to necessary and proper. Yeah, Brent.
I don't understand why this isn't more distinguished from Lopez, because Lopez is talking about federally criminalizing the mere act of possession of an object. This is talking about systemic violence. It throws the stat even back then that 1 in 6 women is going to face gender-based violence of some kind. So you're talking about an entire class of citizens along the lines of really civil rights.
So what they were trying to get at here, what Congress was trying to get at here, is the notion that you have this nationwide problem. And the way to deal with this nationwide problem is that we have to reach local activity, right? But you can't reach local activity if it's deemed non-economic.
But if crimes aren't sufficiently enforced, even at the local level,
Right.
aren't we talking about, to a degree, removing women from the marketplace, from participating?
Well, they're saying that gender violence is not a marketplace at all, right? It's not like you're buying and selling stuff. It's just prostitution, but the actual act of violence itself is not economic.
We're talking about being willing to fully participate fully in society. So basically,
So it discusses the levels of the inferences, right? So in this point, I think we go back to Breyer's comment from before. It's certainly true that if women engage or women are subject to violence, they're less likely to engage in interstate commerce, right? But that's an inference the majority is not willing to make. They said, look, by itself, the act of striking someone, the act of engaging in rape, that specific act by itself is not economic, and therefore it doesn't trigger Congress's authority. You don't look satisfied. I'll agree. The ball moved from Lopez to Morrison. They moved the ball. And Breyer is very agitated about that. He said, wait, but we have this entire big deal saying if you make findings, right, then we're okay. But the court here strains to define economic activity very narrowly. I think that's one way of distinguishing them.
I guess my problem is just that it recites the statistic, but then kind of ignores it. In my opinion.
Well, they don't doubt that there's a substantial effect, but that's only relevant if there's an economic activity in the first place. I said again, I like the way you phrase the question. Whether or not there's a substantial effect on commerce is irrelevant if the local activity is non-economic, right? If the local activity is not economic, the effect is irrelevant. Maybe I phrase it without the double negatives, right? If the local activity is non-economic, the effect is irrelevant. This, by the way, to give you a preview of the Obamacare case, the court held going uninsured is non-economic activity, and therefore the substantial effects were relevant. This actually is the basis for the Obamacare case coming up soon. We'll do that, I think, in a week or so. All right, is everyone with me? So in short, the court here holds that local crimes like murder, rape, family law, family law is not a crime, but local matters like murder, rape, family law, and the sorts, that is traditionally in the province of the state. And Congress cannot regulate it because it's not economic activity. I'll get you a second. There's another issue lurking here with respect to the necessary and proper clause, which is hinted at. Necessary and proper are separate elements. So even if it's necessary, that is useful to have this nationwide scheme, the proper element, propriety, is whether you're intruding on a traditional state function. And it may, in fact, be unconstitutional for Congress to intrude on the police power of how states police local crime. That itself may, in fact, be unconstitutional under the proper element of necessary and proper. So they're actually setting the stage here for the Obamacare decision, which no one would tell that was the time, but there are shreds in there. Alexandra?
So for it's just not possible then for the federal government to like sanction a state for not pursuing rape cases vigorously. Like if there's like a majority of districts in one state that have all these rape charges that don't get pressed against people or aren't pursued vigorously, there's no way the federal government can sanction those states or anything because that's a violation of state sovereignty.
Yes. The court's basic suggestion is there's some matters that are so local that Congress has no authority over them. And if the states are slacking, that's up for the states to resolve when they're on a court. In other words, not every problem can be resolved by Congress. What about the 14th Amendment?
Oh, so the Congress, it says that Congress can enforce.
So good, so good. So Section 5 of the 14th Amendment, which I've mentioned, says that Congress can take action if the states are not providing equal protection to the law. Do you know what the basis of VAWA was? Section 5. Section 5, Joe Biden said, allows Ms. Berzankala to sue Virginia for not investigating the gender-based crime. The court invalidated that provision of VAWA, finding that Congress could not waive Virginia's immunity from suit, what's called sovereign immunity, even though they were trying to pursue its powers under Section 5. Everyone with me? We'll do the other part of Morrison, I think, in a few weeks. But you're exactly right that the second part of Morrison is about whether Congress, under their Section 5 powers, can allow the state to be sued. I saw some hand over there. Yeah.
The federal government can sanction the state.
This federal government can what?
could not legally sanction this.
What do you mean sanctioned?
Like what she was mentioning is that there's no way for the federal government to punish the local government for not pursuing
How can the feds punish the states?
by taking away federal power.
Oh,
That's what I was.
coming next class. Those of you you're reading the spending clause. Can Congress withdraw money from states if they don't do something? Stay tuned for next class. But, and if you want to bring this real current, sanctuary cities. What extent can the federal government punish states that don't do stuff or do stuff that the feds don't like? This is a very live issue, which we'll talk about on Thursday. Dyer?
I just wanted to clarify, you were saying that the policing violent crime is likely unconstitutional because these powers are reserved for the state?
Well, specifically, policing local crimes is something historically associated with state governments. And for the feds to then pass law, it basically supplants the local role in law enforcement. And the court says that would probably not be proper under the necessary and proper clause.
So it would be the necessary and proper clause.
To be precise, what makes it not proper is that it runs afoul of the 10th Amendment. Let's say it again, if you didn't get it. If Congress passed the National Murder Act that says from now on, Congress will prosecute all murders, and local sheriffs have no jurisdiction to prosecute murders, that would probably run afoul of the necessary and proper clause. It's not proper to intrude on state sovereignty protected by the 10th Amendment. I think that's the relationship. Or if Congress passes the National Marital Relations Law, it says we're going to preempt all local domestic laws and have a single family law nationwide. I don't think that would be proper either under the 10th Amendment. Okay. Any other questions on Morrison? So what we have both in Lopez and then modified in Morrison is the idea that if activity is not economic, that Congress has very little authority over it. If activity is not economic, then Congress has no authority over it if it's intrastate. Okay. Anything else on Morrison before we move on to Raich? Yeah, Jen.
Just kind of a little bit. What happens if it's like someone who's committed like a crime in one state and another? So like, would that be?
Don't get me wrong. There are federal murder statutes. There are federal murder statutes, right? But there has to be some sort of connection to, say, commerce. Usually it's organized crime or something like that. So you can prosecute someone for federal murder. There's a great episode of The Simpsons years ago where Sideshow Bob is standing on a point where there are 5 states with borders. And he basically, everyone knows, he fires a bullet and it goes across like 5 state borders. There's more federal murder than that. In fact, there's actually a case in the Supreme Court this term where a U.S. agent fires a bullet in the United States and crosses the border to Mexico and hits someone in Mexico. As a question of whether people in Mexico have the Bill of Rights applying to them, they're just staying there and get struck by a stray bullet. Coming soon. Okay. Anything else on Morrison? Okay. At long last, we get to Raich. This is you asked about it many times. We'll get to it now. And Raich is a particularly special case. For those of you who read the book, my co-author, Randy Barnett, argued this case. So he's very much committed to this case, and it's a fascinating one. And her last name is pronounced Raich, like TCH. It's not Raich, but Raich. And she lives in California. And I love showing this picture because at first glance, like, oh, look, she's so innocent, right? And then you see what's in her hand. It's a marijuana pipe.
Yeah.
How many of you actually noticed that when you look at the picture? None of you? Josh raising his hand. Okay. No, it's a marijuana pipe. A hash pipe, if you will. I also have this picture. Everyone knows what that cone thing is? Vape. Oh, you know who knows what is a vape? It's a vaporizer, which is used to heat up the marijuana, and you can inhale it as a whatever. But she had a very advanced form of tumors that the only thing that would help alleviate her pain was medicinal marijuana. And I think her doctor even said in the record, if she didn't use this, she would either get really sick or maybe even die from the pain. So we're talking about some serious things. She's actually still alive today. Query if the court ruled that she can't use marijuana where she's getting marijuana from, but I think she somehow found a stash. It's keeping her alive. This is a photo of Randy Barnett arguing with her. This is a picture of her on the phone when she realized she lost the case, which is a very sad thing. The Supreme Court doesn't announce when they're going to decide a case. So basically, you have to wait for a phone call, and it hits you out of the blue, and it can be very shocking, especially when this is not some sort of abstract legal issue, but something that can literally keep you alive. All right, let's go down the row. Kiara, I think you're next. What were the facts here? What was going on in California back in the 90s? Well, oh no, sell it? That's actually a big issue. Where did Raich get the weed from? Well, did the doctor give her the marijuana? The doctor prescribed it, right? This is actually a legit prescription. Kayla, where did Raich get the marijuana from? She had a dealer. They call it a caregiver. Isn't that such an awesome word for a dealer, right? It was a caregiver. So, Kayla, did the caregiver sell her this marijuana? They give her free. And where was this marijuana grown? Okay. Did this marijuana ever cross state lines? Did the seeds used to grow the marijuana ever cross state lines? Did the soil used to grow the marijuana ever cross state lines? Did the sun used to grow the plant cross state lines? Did the water, you were supposed to go with this, right? The actual act of cultivation of marijuana, if you have personal experience, don't raise your hands, it's fairly simple. And it can be grown in many different climates, and it doesn't require an elaborate equipment. Think of like, Breaking Bad, right? If you want to cook meth, you need a lot of stuff to travel in interstate commerce, right? If you want to cut cocaine, you need a lot of stuff to travel in interstate commerce. Marijuana is unique in that you can basically grow it anywhere, and it grows, without significant difficulties. Okay, so Carly, what happened? Oh, I'm sorry, one off. Jenna, what happened? What happened to Miss Raich? See, Brian's hat was blocking your name tag. That was a problem.
The DEA
That's it.
and they went to other.
Monson, right?
Yeah, went to her house, and they said that everything she was doing was legal, but they still took her.
Well, legal under which law? Under state law, under California law, she was acting perfectly lawfully, right? Under state law, she was acting perfectly lawfully. There was no problem whatsoever. Now, Carly, what law was she running afoul of?
The Comprehensive Drug Use Prevention Control Act.
Okay, you can call it CSA for short, not Confederate States of America, Controlled Substances Act, right? This was a federal law passed during, I think it was a Nixon administration, on the Let's Get Tough on Crime platform, the War on Drugs platform. And it lumps together different types of substances in schedules. And marijuana is a Schedule I drug. I mean, that's like the same thing as like heroin and cocaine. And possession of it is a federal offense, and you can't have it unless you have a special license from the federal government. Okay. Stephen, so if Congress, passes a law criminalizing marijuana, how can the state pass a law legalizing it? How can that possibly work?
Well, they did it for
The federal law makes no distinction between medicinal and recreational uses. If you see them people in California with pot cards, not all of them are so sick. If you you don't feel well, you can get a card anyway. But Stephen, how can California possibly enact a resolution or a budget resolution? Sorry, a ballot initiative, if under federal law it's illegal? How can that possibly be?
I'm not entirely sure, but did they make this law before?
Oh no, the California law came in the 90s. The federal law came in the 70s.
No, I'm not sure.
So this is a question, right? Can California pass a law that allows you to have something that's illegal under federal law. Jay, what do you think?
I would kind of go back to, they would argue that it's under their police powers that they can do it. If it's not something, they would argue that the federal law is outside of the Congress's power.
But the threshold question, can a state enact a law that conflicts with federal law? No. Why not? What do you think, Al? Looking at him. Steve, you want to take another stab?
Well, I guess I would say that the marijuana use is kind of a local. That's what the response.
I'm asking a more general question. Sir Karen, what do you think?
I mean, federal law trumps
It trumps it when? At what point does federal law trump state law? This is the important point. When the law is enacted?
I guess when it comes into play.
When does it come into play?
When it contradicts.
When does it contradict in this case specifically? What happened here? What did Ms. Raich sue? What did she say?
When they were manufacturing this.
No, Brian?
It would be her conduct.
Her conduct. What was her conduct here?
So her conduct was cultivating and manufacturing, and using.
So Brian, when the police showed up, what was Raich's defense? What did she tell the police?
Well, her defense was that what she was doing was legal under California law.
Prescribed. But when did the conflict arise? Right? What if she said, "Look, the state police show up. They said, look, I'm okay under state law." If they walked away, would she have any problem?
Well, she was still breaking.
Who gave her the problem? It wasn't the state police. Who actually gave her the problem? The feds. So here, follow me here. A state can enact a law that conflicts with the federal law. That's actually not problematic. The conflict under the Supremacy Clause only arises when there actually is a real conflict. And here the conflict was she had marijuana that said was lawful under state law, and the Fed showed up and seized it from her. That was a conflict. She went to the feds, "Hey, look, I have this great state law that protects my marijuana," and the Fed said, "We don't care, we're trumping that now." To make the point differently, Congress cannot force a state to modify its laws. They can't. Congress cannot force a state to do anything. For those of you who read the reading for Thursday, the Prince case, the commandeering case, Congress can't force a state to enact a law. In fact, it's perfectly valid for California to have this law in the books. Let's see, Griffin, let me ask you this question. Can the federal government require California police to enforce and go after marijuana?
No, I don't think they can require them to, but they themselves do.
Yes, exactly. The feds can't force states to criminalize a damn thing. If California wanted to repeal its murder statute, they could do it. If California wants to repeal its rape statute, or if it's, whatever statute you want, they can do it. Congress can't require states to legalize or illegalize anything. So that's why we have now, what's number? Half a dozen or a dozen states, I think, now have some sort of legalized marijuana in various forms, both recreational and medicinal. Even though it violates the Controlled Substances Act. Even though medicinal marijuana is in violation of federal law. So, John, how are people getting away with having pot in violation of federal law? What's going on here? Why are people not getting locked up by the DEA every 5 minutes? Feds aren't enforcing. What do you mean the feds aren't enforcing it? Yeah, well, not just every single person. The feds aren't going after anyone. So about 2-3 years ago, Colorado and I think Washington became the first states by ballot initiative, shocker, to legalize marijuana, period. Not medicinal, walking off the street to a dispensary, buy some weed, and go smoke it. You can't do it outside, but you can smoke it at home. If you've ever been to Denver, the entire city smells like weed. It's awful, but you know where I stand. But it smells awful. because it's perfectly lawful and people are doing it everywhere. Now, as a matter of state law, the state police are like, all right, whatever, it's legal. The federal government could swoop in and police marijuana laws. But the Obama administration issued a letter called the Cole Memorandum saying, look, we're not going to prioritize enforcement of marijuana laws in states that have legalized it. Wink, wink, nod, nod. That means if you have simple possession, we won't go after you. I've written elsewhere this is probably illegal to not faithfully execute the law in this fashion, but that's been the law here. And I'm actually paying very close attention to see if that memo is revoked and seeing if now under the new administration, marijuana laws are actually enforced in a half a dozen states. After the Attorney General is confirmed any day now, we may see a change in that policy. But as a practical matter, the states can't be forced to do anything. The conflict only arises when there's a prosecution or when the feds seize for pot. So this case does not concern the constitutionality of the California law. This case is not about whether the California law is constitutional. In fact, I think California law is perfectly constitutional, right? It provides a right to their citizens, and if the feds want to enforce it, they can do it, but the state can protect its own citizens in this fashion, right? The case also doesn't challenge whether the Controlled Substances Act is constitutional. Congress has the power generally to regulate the interstate drug market. They do. There's no doubt about that, that they're not trying to strike down the entire Controlled Substances Act, as much as I'm sure people would want to. That's not this case. In fact, they don't even contend that any provision of the law is unconstitutional. Rather, the challenge is far more narrow. Raich asserts here that as applied to her, right? This is not what's called a facial challenge. A facial challenge means you challenge the law on its face. In all of its attributes, it's unconstitutional. This is not a facial challenge. This is what's called an as-applied challenge. As applied to me, Angel Raich, this law is being applied in unconstitutional fashion, right? As applied to me. Brian, why as applied to Raich did you say this law is being applied in unconstitutional fashion?
Well, marijuana was legally, and so it constitutes, drawn over borders.
Yeah. Yeah, she says that with respect to local cultivation use of marijuana, in compliance with state law, that this is not within Congress's commerce powers, nor is it within Congress's necessary and proper powers. So the first thing you'll notice about this case is some of the votes change from Lopez and Morrison. Both Lopez and Morrison were 5-4 decisions. In the majority, you had Rehnquist, you had O'Connor, you had Scalia, you had Kennedy, and you had Thomas. 5, and then the 4 liberals, you had Breyer, Ginsburg, Souter, and Stevens. The votes in this case flipped. In the majority, you had Stevens, joined by Kennedy. And Scalia concurred in judgment, although barely. So why did Justice Kennedy change his position? This is a thing that law professors love to discuss without any explanation either. He apparently had a relative who died of a drug overdose or something, and apparently had a very strong sentiment about drugs. So what we call this the drug exception to the Commerce Clause case. Although you'll see in the Obamacare case, Kennedy went back the other way. As for Scalia, his opinion was very nuanced. We'll get there in a bit, but he did not really agree with the majority at all. His opinion was much. I go back and forth whether Scalia was right. I think Scalia had a very good position here, but the majority is now Stevens. And Stevens doesn't try to overrule Lopez or Morrison. He can't because Kennedy's with him. So what they try and do, I think, is read Lopez and Morrison, again, as narrowly as possible. Right? They don't overrule them, but they read them narrowly. And Stevens says, this case isn't really even governed by Lopez. This case is governed by Wickard. Troy, why does Stevens think this case is governed by Wickard? Wickard v. Filburn.
I was comparing to how, I guess on the market, and how it defines the market of the price in the market and affects the market the same way that green did.
Well, first let's start with a more basic concept, right? All right, let me ask this question again. Under Wickard, what can Congress regulate? Economic activity, right? Even if it's purely intrastate, within one state, Congress can regulate economic activity. Why? Because it has a substantial effect in interstate commerce, and the Congress wants to have this nationwide price scheme, and it's both necessary and proper to regulate this to get at the local problem. Okay, Troy?
Didn't you say that the CSA was, they gave a definition of economics, and basically said that's exactly what the CSA is.
That was my next question, right? Okay, so you can answer, Troy. Why is a local cultivation of marijuana economic activity under the majority's opinion?
They say because it would, they basically affect the market just like it would, when, if you took it off the market, then they said that, but you would, they would be able to restrict it, prohibit it from the market, so when in the market, then.
Philip, why is this economic activity?
Because they say that they don't pretend that there's not a black market, and in light of this, they were likely to use the black market to get the marijuana they want anyway. So this locally growing is affecting the supply and demand of that black market.
Okay. Christian, how do we know what economic activity is, according to Justice Stevens? Looking for a very specific answer. It's a very specific answer. It's one of the funnier parts of the opinion.
Well, I imagine it concerns a market, though. Not sure.
No. You know what I'm thinking of? No. Where does he look for to define economic activity? You know what I'm thinking of? Where does Justice Stevens look to define economic activity?
What's in the dictionary?
The dictionary! Webster's Third Dictionary. And how does it define in Webster's Third? Finish it up. Anyone have it? Yeah, Sergio, go for it.
It refers to the production, distribution, and consumption of commodities.
Ah! Okay. The production, distribution, and what's the last one?
Consumption of commodities.
Okay, so I want to put a brief note. This is the portrait of Justice Scalia hanging in the Supreme Court. His hand is on a copy of a dictionary. It's Webster's second edition. Scalia hated Webster's third edition because they said they made all these changes to language that were not justified. So he would only cite Webster's second edition dictionary. So this is actually a subtle dig at Scalia. Not that you would ever in a million years even know that. But the citation to Webster's third was basically saying, Scalia, screw you, right? So anyway, in the portrait, he has a copy of the Federalist, Sir Thomas More, and Webster's second dictionary. Those, and a picture of his bride Maureen in the background, right? Those are things most important to Scalia, which I find hilarious. That's what they put in his portrait. It's a very good portrait. Here's a full size of it. Let's cut off. Okay. All right. So where was I? So Christian, I'll back to you. So how then is the local cultivation of marijuana economic activity?
Well, it talks about how the prices could actually draw the car comes to the market. Same way the drawing market.
Right. So here's actually a picture of the President and First Lady walking right past the portrait. You can see he's right there. He's got the Sir Thomas More. He's got the Federalist, Webster second right there. It's a very good picture if you have a chance to go to the court to see it. So it works like this, okay? Randy, no one doubts that Raich only uses her weed locally, right? She's not selling it. She's not going anywhere else. But what could happen if it's not Raich, but maybe someone else is less honest? What could they do?
Like the person that does it?
Yeah, someone not as honest as Raich, right? Someone wants to make a profit. Right. So the thinking is like this. If the state's allowing the local production of marijuana, it creates a very easy incentive for someone unscrupulous to load up in their car and drive to Oregon or drive to another state that borders. For Congress to effectively regulate the interstate drug market, they need to reach local economic activity, which is cultivation. So you see the bridge, right? First we say this is economic activity. So under Lopez and Morrison, this conduct can be reached. And because it's economic activity, then we go to the necessary and proper clause. And Stevens writes that it's both necessary and proper for Congress to reach this local activity in order to regulate the nationwide drug market. In the same way that Wickard involved a nationwide price scheme, they tried to make the price of the price of wheat standardized nationwide. Here, Congress is doing the opposite. Instead of regulating the price, they're regulating the supply. And they're trying to make the supply of marijuana across state lines 0. And therefore, right? And therefore, because this economic activity in the aggregate has a substantial effect in interstate commerce, Congress can regulate it. Brent, why are you laughing? You're laughing at me.
I know I'm not looking at you.
Oh, good.
I don't agree with the reason.
All right, why don't you go with the reasoning? You're really getting antsy there. Okay, just a second, Jamie.
It's something that there's no profit. There's nothing to ask for.
But what if Raich, found hard times and decided to start selling the pot? What if she, changed her mind?
What if someone breaks the law? Well, then you would enforce the law. I mean,
Could you? No. But could you enforce the law? Oh, I see. So you say you only enforce if you start selling it outside, and then becomes an economic activity. So a second, Jamie. So Brent's point is this: like, look, if she actually decides to start selling it, then arrest her for engaging in sales. But what if the feds come back and say, you know what? We don't want to have to wait for that, right? We want a proactive approach. We want to stop it before she even gets to that point. We want to let her sell it because we won't let her have it in the first place. Why is that not rational? We're saying we need to stop this problem at the bud, literally, right? We need to nip it in the bud and stop it at square one. That's good. I'll use that one again. Yeah. I don't always remember these, but yeah, Jamie.
Okay. When I first read this case, I first thought, how did the feds find out about a regular person who's just picking up pot from a dealer? And then 2, if they're legalizing it state, then there must be companies that are already selling it legitimately, which I think was before this case.
But the law at the time didn't allow the sale. The caregivers only did it for free. So right? This law was drafted very narrowly to avoid the sale issue. Because once you have the sale issue, you can be shut down by the feds. This is a very narrowly drafted law.
I watched this documentary on Vice that talked about how they were just trying to shut down local.
Now California legalized pot generally. This was before.
Yeah, it just reminds me of this. Like, all the people that were growing pot and fighting since the 70s to get it legalized are being shut down
by the conglomerates, right?
The huge. I mean, honestly, and like, it just looks like a little bit of.
So a little bit of economics. You want to hear the Baptist and bootlegger concept?
Yeah, I watched your old video.
Oh, okay, thank you. Did I talk about this last year at the same time? So what did I say last year? Okay, so what's Baptist and bootlegger? That's fine.
So like the Baptists might lobby saying that we don't want liquor here for a certain reason.
Morality.
Yes.
Yeah.
And then the bootleggers do want it. They want it illegal because that's how they make their money.
Yeah.
And so it's really a pretty difficult.
Yeah, so what we have here with marijuana, right? They're the Baptists. We want pot to help everyone. We want this beautiful herb that makes us all happy. And then you have the conglomerates that Jamie's starting to come in. The big companies like, screw this, right? We'll have the economies of scale, put these little guys out of business. And by the way, we'll make it a lot of regulations. We'll have to pay taxes to grow this marijuana. We'll have to have facilities. We'll have to have licenses. Put the little dealer out of business, and we'll have mega pot, right? Whatever the marijuana dispensary is called. So this is indeed not rare, where companies who can benefit from regulations want regulations because they put the little guy out of business. That's why most regulations don't exist to harm big companies. They exist to harm the little guy. You'll talk about this in various junctures this semester, but don't assume that when Congress enacts a regulation, it's meant to harm big guys. It's usually meant to put the little guys' competition out of business. We call it barrier to entry.
If this was an issue of the sale of marijuana, then couldn't you argue that maybe, why would it be, is it proper and necessary to ban marijuana? Would you have to prove the like negative effects.
So the key part here, though, is if it's an economic activity that's a sale, right? Then it gets very easily under Whipper, right? Because it's an economic activity. But the key move here, and I'll try and summarize majority, the key move here is say, look, the cultivation of marijuana, because of Webster's third dictionary, is an economic activity. Therefore, because it's an economic activity, Congress can ban it because it has a substantial effect in interstate commerce. And not even that Angel Raich by herself will have a substantial effect in the aggregate. If every single person in California decides to cultivate marijuana, that can then spill over into Nevada, and that's where you get the regulation of commerce. Because that was not economic activity. You only get to the, I think it was your question at the beginning, you only, but I answered it, you only get to the aggregation principle if you have economic activity. Webster's third. If the activity is not economic, then you don't get to the aggregation principle. In other words, you cannot aggregate non-economic activity. This is what, again, the Obamacare case, keep teasing it. They find there's no economic activity by going uninsured. We'll argue that next week.
Kind of reminds me of like Minority Report, like kind of like what Brett was saying, like it's gonna be for that you know they're going to like fight crime.
Pre-crime, yeah, exactly. Pre-crime, right? It's so. I mean, it's not an insane concept, right? Why should the government have to wait till she's actually shipping pot across state lines? Why can't the government act preemptively and say we won't let you have it in the first place? It's like a preemptive law enforcement. I mean, it's not insane to say we're going to dry up the supply now. It's a lot easier to bust the seeds than to bust the shipments, right? So if we take down her plants now, she can't grow more bales, and she can't ship them. I mean, it's perfectly. Actually, that makes sense. The difficulty of this opinion is whether, in fact, it's an economic activity. Growing weed that's never sold, is that an economic activity? But because of Webster's third, the answer is yes. I'm mostly exaggerating, but that's Stevens' opinion. And believe me, he chose Webster's third on purpose. Scalia hated that dictionary. There's actually an article, what was his name? The On Language feature in the New York Times, where Scalia actually sent a nasty letter to the Webster's third and went back and forth. It was an entire thing. He was a remarkable guy. He did not suffer lightly fools. Yeah, Heather.
Have you ever looked to see what the second says about economics?
You should do that. I don't remember, but I think I might have looked at some point. Yeah.
So, like in the Wicker case, they talk about, well, there's the problem with the growing the weed was that it would mess up, it would make the prices fluctuate. So, is there today when Congress makes a law, they have to say what's wrong with, like, what's the negative effect?
So here's the other issue the majority I'd like to discuss. Does the majority require Congress act precisely with scientific precision of assessing what the effects are?
I guess not.
Not. The court applies here the sort of rational basis review that Justice Breyer loves, right? If Congress can conceive of some way that Angel Raich's little marijuana in her garden, she didn't have a garden, but in her district, can affect something in a different state, that's enough for us. The dissent, if I can move on to Justice O'Connor's dissent, says, look, Congress didn't make a damn finding about this, right? There's nothing in the history of the Controlled Substances Act to show that they were concerned with locally grown marijuana. The court is basically manufacturing. They're making this up after the fact to defend it, which is exactly what Breyer did in Lopez. The same sort of piling inference upon inference that was rejected in Lopez was adopted in Raich. So these cases are very difficult to square together. They're very difficult to square together. And again, I don't say this lightly, but this is the drug exception to the Commerce Clause, because Justice Kennedy was afraid of drugs. But the big distinction, the one I want you to retain, concerns whether this is economic activity. Stevens says because it's economic activity, then we can go to the aggregation principle. Jamie?
When people get put in jail and the state has to pay for it, is that considered economic activity?
Give me more. I'm not sure the context.
I was just thinking about like how a couple years ago, like Dallas County released a whole lot of people that were in jail for marijuana because it was just costing the state too much money for such a small portion of drugs. I didn't know that.
Well, are you saying could Congress prohibit the states from releasing prisoners? What would the federal law be in that case?
I was more thinking along the lines of how you were saying earlier, like who can go and enact if we have a contradiction of state and federal. Why aren't more people? And the guy back there was like, federal has to come in. Why isn't federal coming in more?
Well, certainly, if there's a problem, if the state police are releasing criminals, then Congress will pass a statute saying we will now start arresting more prisoners because the states aren't doing their share.
Does it not cost federal more?
Sure, it does. Yeah.
So if they're starting to think it's just not that big of an issue relative to all the other issues they have, they're just not going to be as harsh on it.
So under the Raich standard, it's a rational basis review. As long as Congress could have had some good reason, that's enough. They're not going to put much scrutiny there. So hand over there. Troy, then let's go into Scalia's dissent. I want a concurrence. I want to make sure I have time for it.
So, if you're in prison for breaking a state law and you're in state prison or state jail, and they'll go come in and say you can't release those prisoners, we're going to enforce your state law. Can you do that?
The federal government cannot enforce state law. They can enforce federal law. So the feds can't arrest you for a state violation. They can arrest you for a federal violation. And indeed, you may not know this, but the double jeopardy clause, right? You can't be tried twice for the same crime. Surprise, surprise, doesn't apply to the state and federal government. So under what's called the dual sovereigns doctrine, the states can prosecute you once, and the feds can prosecute you again for the exact same act. Arrest them and charge them, yep. They have to retry them. Let's talk about Scalia, because his opinion, I think, is the most important one in this entire case, and was something that really helped define the Obamacare challenge in define the Obamacare challenge in many regards. Scalia is like this. He concedes that this activity is wholly intrastate. But what's important for him is that Congress has this nationwide policy to eradicate drugs. So it's not so much whether it's commerce, it's necessary and proper. Scalia says it's both necessary and proper for Congress to go after this local weed in order to dry up the nationwide supply. That if Congress fails to go after this local weed, it will eventually contribute to the nationwide supply. So his idea is all about necessary and proper, that we need to reach. And he quotes from Lopez. There's this bit from Lopez that says, Congress can regulate an essential part of a larger regulation of economic activity in which the regulatory scheme could be undercut unless the interstate activity were regulated. I'll read that again. Congress can regulate an essential part of a larger regulation of economic activity in which the regulatory scheme could be undercut unless the intrastate activity were regulated. What does this mean? Congress can go after local stuff if it's important for a bigger regulatory program. Right? Congress can go after local stuff if it's important for a nationwide plan of eradicating drugs. And Scalia says, when you're looking at the necessary and proper clause, the only question is whether the means chosen are, quote, reasonably related to the end. In other words, if Congress wants to get rid of marijuana, is it reasonable for them to go after local pot to effect that goal? Yes. If Congress wants to eradicate the nationwide trade of marijuana, can they go after local weed? It's reasonable, Scalia says. And for that, he would vote to uphold the law. And he actually specifically cites McCulloch v. Maryland. You can't forget about that case quite yet. The proposition that Congress's powers under necessary and proper are very broad. Justice O'Connor says that this decision merely eradicates the difference between what is national and what is local. It eradicates the distinction and reduces Lopez to a nullity. That if you can define economic activity so broadly, even the gun was economic. I think she was actually right about that, right? I think this was Camry's question earlier. If you apply Stevens' Webster third definition to the gun in Lopez, that was probably economic activity. So this doesn't overrule Lopez, but it tweaks it in a way. And O'Connor stresses this prohibits states from experimenting and using federalism to protect freedom. And of course, we have at bottom Justice Thomas. Justice Thomas would be willing to renegotiate everything, revisit the New Deal, and restore the original meaning of the Commerce Clause. Questions on Raich? Yeah, Alexandra?
So would you say it's important to keep in mind that O'Connor basically says that this case like opens up a page for Congress?
Yeah, and O'Connor only got 3 votes, but table that till you get to the Obamacare case, because that's the more recent statement with Roberts and Alito instead of Rehnquist and O'Connor. Raich was decided shortly before Rehnquist died. He was on basically his death, not deathbed, but he was close to it at this point. Yeah, James.
You're talking about what Scalia says that the means have to relate to the end.
Yeah.
So the end being just kind of.
The end is having an interstate drug market,
Yes.
Eliminating the interstate drug
So it
market.
doesn't have to. Congress doesn't have to really. They don't have to prove that marijuana is bad. They only have to prove that they're avoiding.
Yes. Yes, they're trying to dry up the interstate marijuana market, and to do that, it's reasonable to reach locally grown marijuana. All right, so if I can summarize in 30 seconds on my way out. Lopez, Morrison, and Raich are 3 cases that are somewhat tough to square together. But at a minimum, Congress can only aggregate once it's first an economic activity. But the decision to label something an economic activity is very difficult. And this is where, when we get to the Obamacare case, is the choice of going uninsured economic activity to get you to the aggregation principle? And even if so, is the requirement to make people buy insurance proper? That is the Obamacare case. Thank you very much. Come for questions afterwards, and I'll see you all on Thursday.